Nancy Cavey, National ERISA and IDI Disability Attorney, and I want to welcome you to Winning Isn't Easy. Before we get started, I have to give you a legal disclaimer. The Florida Bar Association says I have to tell you that this podcast is not legal advice. But I will tell you that nothing will ever prevent me from giving you an easy-to-understand overview of the disability insurance world, the games that disability carriers and plans play, and what you need to know to get the disability benefits you deserve. So off we go. One of the most common calls I get in the course of my practice goes something like this. Help! My ERISA disability carrier plan used a nurse or a peer review provider to review my medical records, and they denied or terminated my benefits. Can they do this? Well, I have to tell you that ERISA disability carriers or plans are not in the business of paying disability insurance benefits. When you submit a claim for your disability benefits, one of the first things the adjuster is going to do is to get a copy of all of your medical records. They're going to give those medical records to their in-house nurse case manager or their in-house liar for hire peer review doctors who may not even be qualified to render an opinion about your particular medical condition. What they are going to do is to look at the basis of the diagnosis, what objective evidence supports the diagnosis, what treatment you've gotten, your response to the treatment, what your doctor has to say about your restrictions and limitations. So they're going to be cherry picking these medical records to do an analysis as to whether or not you are capable of doing your own occupation. And they'll do the same thing at the any occupation stage. Now, what will happen is will be times when they'll even ask you to undergo an independent medical evaluation or a functional capacity evaluation, because these are tools in the carrier's denial or termination toolbox. And so they're going to pull out each of these tools as appropriate to your case to create a reason to deny benefits. So what do you need to know about these denial or termination tactics? Today, I'm going to talk about three things. The first is, can an ERISA disability carrier use a nurse-only review to deny or terminate your benefits? 2, can an ERISA disability carrier or plan use a physician to review your claim to deny or terminate benefits? And what's the not-so-independent medical evaluation game I need to know? Let's take a break for a moment before we get into this episode.
You've been robbed of your peace of mind by your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claims process. Request your free copy of the book at caveylaw.com today.
Welcome back to Winning Isn't Easy. Can an ERISA disability carrier use a nurse-only review to deny or terminate my disability insurance benefits? Now, I will tell you that it's not uncommon for a disability carrier to use a nurse to review the claim to determine eligibility for your benefits, to determine the nature of the restrictions and limitations that have been assigned, the appropriateness of the treatment that you've gotten, and whether your complaints of pain and dysfunction are consistent with the examination finding or diagnosis. Often they are going to have an in-house nurse answer those questions for them and then create a reason to deny or terminate benefits. Are you surprised? Well, you shouldn't be surprised. But if you've gotten a denial or termination letter, you might be surprised to find that the denial letter does not accurately or completely summarize your medical records. It excludes relevant information and generally mischaracterizes your medical records. You might be surprised that if you Google the name of the nurse case manager, you might find that the nurse has no experience in the nature of your disabling medical condition. And you might be surprised to learn that rarely, if ever, has the nurse ever contacted your physician to request additional information or clarification or input. So what's next? Well, unfortunately, you're going to have to file an appeal. And that appeal is a trial of your case. And that appeal has to be submitted within 180 days of the date of the denial, or you can lose out. Let's talk about how the ERISA regulations can help you with that appeal letter. Now, under the ERISA statute, the disability carrier plan has to provide a policyholder with a reasonable opportunity for full and fair review of the claim and an adverse benefit determination. That's found in 29 CFR section 2560. 503-1, parens H, parens A, 3, period. The section requires that the disability carrier or plan provide that when you are your claim has been denied, that if it's been based in part on a medical judgment, including a determination with regard to a particular treatment, drug, or other item is experimental, investigational, or not medically necessary, they have to consult with a healthcare professional that has the appropriate training and experience in the field of medicine involved in this particular medical judgment. So there's some key phrases in this ERISA regulation. The key phrase that's applicable to a review by a nurse consultant is whether or not there's a medical judgment being made by a nurse. Unfortunately, the ERISA regulations don't define what the term medical judgment means. So let's look at how one court decided if a review by a nurse consultant was a medical judgment. And this is the case of Carl Mechie versus MetLife. It's a Louisiana court decision. And in this case, the nurse concluded that Mechie's neck and shoulder pain fell within a pre-existing condition exclusion. That's one of the policy defenses that disability carriers can raise. The nurse had thoroughly reviewed the records and didn't have to resolve any conflict or difference of opinions between the two physicians involved. One was the treating physician, one was the peer-reviewed doctor. And the court felt that it was really important that why, in this case, the nurse consultant's review did not violate the ERISA regulations. So the court said, look, it's undisputed that Mechie had undergone a spinal fusion at L405. It was undisputed that he had medical treatment for his back condition in the time frame that would be applicable for the pre-existing condition exclusion to be invoked. That the nurse consultant made no medical judgments, and the nurse didn't comment on the appropriateness of any medical care and didn't disagree with any of the diagnoses. And as a matter of course, the nurse consultant didn't have to resolve any difference of opinion. And in that instance, the court said, well, this use of a nurse is okay because there wasn't the exercise of medical judgment. Ultimately, the question is, can a nurse-only denial be upheld in the court? Now, ERISA legally allows a qualified nurse consultant to review a claim. And one of the key issues is, are they qualified? And that's particularly true if the medical condition involves something like chronic fatigue, POTS, Ehlers-Danlos, migraines, complex medical conditions. If we suspect that the nurse consultant isn't qualified, you, through your attorney, should be attacking the review as insufficient. But I also want you to understand that the courts have accepted the opinions of nurse consultants who have reviewed X-rays, MRIs, doctor's notes, and concluded that there was no objective evidence of medical impairment. That, of course, will lead to a claims denial. And courts will look at the material documents in the records that would prove that this particular issue is something that a nurse may not understand, but that a doctor would. And in that particular case, a nurse consultant's review is not a violation of ERISA if it's something that they would commonly understand in the course of their practice as a nurse. When you get into court and you're arguing about this, there is what's called the substantial compliance standard in determining whether or not the nurse has substantially complied and their activities have complied with ERISA regulations. So the federal judge will use this substantial compliance test in determining if the failure to consult a specialist contributed to a finding that the administrator didn't substantially comply with the ERISA procedures and regulations. So they're going to look at the record as a whole and say, okay, we will find that there can be substantial compliance if the policyholder or plan beneficiary knew that what evidence that the decision maker relied on denying the claim. So in other words, as part of the appeal process, they have to give us everything that the nurse had and considered in rendering their opinion. And if we don't get that, or if we see that the nurse didn't consider all of the relevant material, obviously that is a ground for attack. Now, the court may also find that there was substantial compliance if we had the opportunity to address the accuracy and the reliability of the evidence. So one of the things that we want to attack, and we ask for, by the way, is the CV of any medical provider that's involved in the carrier plan's decision to deny or terminate benefits. We also ask if they used any kind of policy or procedure manual, because carriers or plans do, in fact, have policy or plan manuals that tell their employees how to evaluate certain medical conditions. So we want to use these as a way to argue that the opinion is not accurate and it's not reliable. And certainly whatever the policy or procedure manual is not consistent with accepted medical practices in evaluating this particular medical condition. Now, the court may say, look, if the decision maker considered the evidence presented by both parties prior to reaching and rendering the decision, there may be substantial compliance with the rules or regulations. So we always want to attack this, again, by looking at the claims notes and the nurse's report to see what evidence did they consider. Did they consider all the medical evidence? Did they cherry pick the medical records? Did they ignore what your physician had to say? So we want to obviously be able to attack this. And it can be a crapshoot depending on what's in the claims file, the professional background of the nurse and the methodology or lack of methodology that was used by the nurse and ultimately by the carrier and the plan in creating this denial or termination letter. Now, remember that the denial letter will invite you to file appeal within 180 days, which you should do. And you should do it with the assistance of an experienced ERISA disability attorney. You only have 180 days in which to do this appeal, and it is the trial of your case. So you or your lawyer want to point out in the appeal that the denial was based on the insufficient nurse's review and challenge the basis of that denial. It's only then, I will tell you, that the disability carrier wakes up. And what they'll then do is they'll obtain an in-house or external liar for hire peer review, or maybe even an IME to justify the claim's denial. Then they'll have the nurse's opinion reviewed by their physician, who, of course, is going to endorse and rubber stamp the nurse's opinion. Wow. Now they've fixed that unreasonable denial, but you still have the right to rebut the new liar for hire doctor or nurse's opinion for the basis of the denial. And you can see that this is a game that does really require the assistance of an experienced ERISA disability attorney. We need to take on the liar for hire nurse or doctor's qualifications, what they have looked at, what they've cherry picked, and how they have used medical reasoning, in quotes, if you will, to reach their conclusion. And we're not afraid, as you shouldn't be afraid, to use perhaps an FCE or your own IME to attack the basis of the nurse's or liar for hire doctor's opinion. Got it? Well, in our next segment, I'm going to talk about the use of those liar for hire peer review doctors in greater detail. Let's take a break.